We will go on the record in the matter 23 CF 169, 23 CT 58, 25 CF 97, State of Wisconsin versus Patrick Stewart Jr. The state appears through Special Prosecutor Aaron Marco by video conferencing. We have Glenn Keene, Defense Counsel, in person with Mr. Stewart. We're set today in these matters for status conferences. Mr. Keene, please update the court.
Yes, Your Honor. Just been present the offer from Special Prosecutor Marco to my client. We're not agreeing this time. However, I belatedly got Mr. I am the discovery this morning, belatedly on my part, that for Mr. Stewart. I would ask for one more status for the following reason, because on the OWI charge, Mr. Stewart is planning on working with Ms. Anderson for the IDIP.
Setting this for trial. These are too old. We're dealing with a 23 case. Actually, we're dealing with two 23 cases and a 25 case. So we're setting them for.
Okay, pause right there. Did you catch that shift? The judge just made it crystal clear these cases are old. In court terms, that's a warning shot. When a judge says it's too long, what they're really signaling is calendar pressure and patience running thin. And here's why that matters legally. Defendants have a constitutional right to a speedy trial. But ironically, courts also have an obligation to move cases along. When things drag into multiple years, like these 2023 cases now creeping into 2025, judges start pushing the gas pedal. Translation, the negotiation window just got smaller. So now the defense is trying to buy time. But the court is ready to roll the dice with a jury. Question for you. If you're the defendant here, do you gamble on trial or lock in a deal while you still can?
For trial. It's too long.
Yes, sir.
So with regards to which case would you like to set first, Mr. Marco? Would you like the OWI third or the THC, either one? And we're going to need lab for both. So, and I'm going to guess, since it's such an old case, we do have or should have the lab results. While we're waiting for Mr. Marco to identify the lab analyst so that the court can call and get this matter set, what is the offer that has been received that is being rejected?
The offer called for Mr. Stewart to plead to one of the felony counts in 25 CF 97 and in an OWI in 23 CT 58, with other counts dismissed and read in. Calls for standard terms for the OWI and a PSI on the 25 CF 97.
PSI free to argue?
Yes, it's
capped, or
I don't remember if it's capped, but
okay. All right. In the time being, Mr. Stewart, I'm going to set the matter for trial, and I'm going to set I'm also going to set the 23 or the 23 CF matter for trial as well. So I need that lab analyst because we're going to set two trials. In the meantime, before the trial comes, you would have the ability to participate with Ms. Anderson at your choice, but knowing the risk that it may go to trial or it may not. But that could serve in your benefit with any other negotiations with Mr. Marco. But these are very old cases and I need them to move. Mr. Marco, do you have the lab analyst for the 23 CT case?
Michael.
2031, ending telephone 608-266-2031.
and D. Marco, sorry. Could I suggest that if we're going to try the 23 cases, I would suggest that having the 23 CF 169 first would make more sense, because
I'm setting them both, so we'll just see what happens
in terms of availability.
Of how the lab analysts and those dice roll. That's what's going to happen, quite honestly.
Yes, sir.
And what is the is it an FX number?
23.
All right, and can you locate the lab analysts for the other matter too, please? And I will go off the record right now and call the hygiene lab.
And just like that, March 3rd is locked in. That's the countdown. When the judge starts calling lab analysts and setting firm dates, this case shifts from talk to trial mode. In an OWI case, lab results are everything. That's the science. That's the backbone of the prosecution. Now the pressure's on. Does Stewart complete the program and try to negotiate, or gear up to challenge the evidence in court? Clock's ticking.
Toxicology, this is Susan.
Hi, this is Judge Mogen in Burnett County, and I am calling to set an OWI trial with Mike Knutson.
Okay.
And do you need the FX number?
Hang on. Yes, I can take that now.
FX, it would be 23 FX 010543.
Patrick Stewart.
Correct.
Okay. And the date?
Well, Mr. Marco and Mr. Keen, could you do March 3rd? And that would give you sufficient time to complete the program if that's the route you wish to go.
Thank you. Yes, I'm available March 3rd.
Mr. Marco?
Yes, I would be available March 3rd.
All right, March 3rd, does that work?
Actually, yes, you would be a number one with Michael.
I so appreciate it. Everything is falling into place. Thank you. We will take March 3rd.
Can I just get one last thing from you? Can I get a contact name and phone number, please?
It would be Aaron Marco.
7-1.
That's all I need. Thank you.
All right, thank you so much.
Bye.
Thank you. Now let's get a final pretrial. Mr. Marco, could you do, and Mr. Keen, February 12th at 10?
Yes.
I'm sure I can, Your Honor. I'm just double checking.
Okay. All right. So we're not on the record yet, but Mr. Stewart, if it is your intention to try and do that program, this gives you enough time, but you have to start it immediately,
Okay.
like right away. Okay?
The IDIP program.
Yes.
Okay.
And so see, I'm setting it, I'm doing what I need to do for my job, and I'm still giving you time to do what could benefit you.
Okay, thank you.
Okay?
This right here, this is judicial balance in action. The judge is doing two things at once, pushing the case forward and giving the defendant a lifeline. Setting firm trial dates keeps pressure on everyone, especially the defense. But leaving room for the IDIP program, that's smart leverage. If Stewart completes that program, it could significantly soften negotiations. Judges love effort. They love documented rehabilitation. It changes the tone of a courtroom. But here's the tension. If he doesn't start immediately, like the judge warned, this goes straight to trial. No more extensions, no more delays. And now the clock is ticking. So ask yourself, is this a genuine opportunity for redemption or just buying time before the inevitable?
All right. Now, other lab, Mr. Marco?
It does not.
Sense. I'm not coming down on you at all because I don't even know if you've been on the case that long. Well, then let's just go ahead and set that one and we'll do it after March. And then Mr. Marco, you can see about getting it sent in.
I'm available then as well, Your Honor.
All right, we'll just set right now, as of right now, we'll just do the February 12th at 10 for a final pretrial for that one as well.
Yes, ma'am.
Because quite honestly, if you're looking like you're going to accept the agreement, we should know by then with all of it, right?
Yes.
Okay. Back on the record, same appearances. As previously noted, the court has now set trial dates for the 23 CF 169 case. The court has set April 7th for the trial date. For the 23 CT 58 case. The court has set March 3rd for the trial date. We are in number 1 with lab analyst Mike Knutson. We have set a final pretrial date for February 12th at 10. The court has set these dates for trial to keep the calendar moving and to keep the cases and the disposition continuing. However, it has been scheduled with enough time to allow Mr. Stewart to partake in the IDIP program and to have the benefits of any perhaps offer that's been extended and or to be able to continue to negotiate with the state. So those matters have been set. Anything else we need to discuss, Mr. Marco?
I don't believe so. Thank you.
Thank you, Mr. Keen.
Yes, Your Honor. The court in 23 CT 58 had published an order on October 8th forfeiting bond. However, and that was for a failure to appear on June 9th. However, on June 9th, the order was that was for Mr. Stewart to appear within 30 days for it to be forfeited, and Mr. Stewart appeared June 20th.
Talking about what in October? I have nothing signed in October.
And
Are you talking 2024?
no, October, the 2023 CT 58.
Okay.
Okay. An order was published October 8th this year to forfeit bond of $1,500.
Yes, I see that now. It's only in the one case. It's not in the other matters.
Right. However, the the proposed forfeiture of bond, there was.
File a motion, file it in paper.
Yes.
All right. And
Yes,
then
sir.
we can, I can get the state's response and then we can
Yes,
go
sir.
from there. Because it's kind of, it's hard when you're on the spot, when you're trying to remember what happened back in June versus what happened in August or whatnot. So go ahead and file something and I'll take a look at that. And
Yes, sir.
we'll address that. Mr. Marco can put in his 2 cents and the court will look at all the facts, okay?
Yes, sir. I mentioned it because it was posted as an order without a hearing, but fair enough.
Well, generally, that's what happens. They get 30 days to be able to file anything in the court. Apparently,
Right.
nothing was filed. Then the state prepares its order and the court signs it.
Right.
Okay. All right. So anything further from that?
No, Your Honor.
All right. Thank you. Then we are adjourned.
Thank you, Your Honor.
Thank you.
I need my paper from that.
State of Wisconsin versus Laura Freer, except Ms. Freer has now shown up for court at 9:38. Ms. Freer, why are you late?
I don't know.
Next time, leave earlier, okay?
Yep.
Mr. Keen, warrants are quashed. Please update the court as to the status.
Yes, sir. And just one thing I will note is that Ms. Freer is late, but I don't know if you can hear it, but she was obviously exerting herself to get here because you can hear heavy
It
breathing.
doesn't matter to me.
Okay, I understand, but some people catch it. All right. The status is that Ms. Freer, to qualify for a plea offer, needed to complete substance abuse treatment. Ms. Freer has completed 3 or 4 of the sessions, and Ms. Freer let me know that her provider was expecting 10 4-hour sessions. So it's fairly, it's outpatient, but it's a fairly intensive amount. And I think if we schedule sentencing roughly 2 to 3 months out, that would provide enough time for Ms. Freer to have completed the remaining sessions and for us to provide that to the district attorney's office.
All right. And in your sessions and doing your things, do you take any random drug?
Yes,
Screens?
yep, that's required.
It is required?
Yep,
With all of your sessions, or do you go in randomly?
it's randomly.
And everything's been good?
Yep. Sorry, I can't get my phone to turn off or turn down or anything or even answer it. I couldn't.
I would talk to somebody.
Yeah, the screen's all cracked up.
And this is your case, Mr. Schmidt?
Yes.
What about January 29th at 10? Or I can do later in the afternoon if that would be easier for you to get here, Ms. Freer.
It doesn't matter to me.
I'm open at any of those at that date.
All right, January 29th at 10.
Okay, well, I'll get your thinking. Okay. Well,
And the court is on the record still, and I'm setting aside the forfeiture